All right. David Hernandez. Are we ready on David Hernandez?
You're still downstairs, Your Honor.
Oh, he's downstairs. All right. On your case, it is a plea on insanity, correct?
Yes, ma'am.
All right. So Judge Carruthers is available to take this plea at 2. So we're going to send him down there to take it there. The reason being is because of the nature of the offense. Judge Carruthers is going to give him instructions about what facility he's going to be placed at.
Okay.
So,
Yes.
and I will tell you, they're in trial, closing arguments, but he said he'll be ready by 2.
All right,
Okay.
Judge.
Thank you.
All right. And then Mr. Churek, after that, Judge Carruthers' court will be the one who's supervising him.
Right.
All right, thank you. And everyone, as soon as your client is brought up, or if you have someone who's on bond and you're ready, just approach the court and let me know. You have someone on bond?
Yes, Judge.
Oh, who is it?
Tyrone Shepherd. We're ready. to plead
All
in
right.
this case.
Tyrone Shepherd.
We're supposed to.
And counsel, here's this, if you want to walk around. Thank you.
Just be sold.
I know, right? I know.
Oh, Jason, let me give you this. Okay, thank you. All right, if everyone could please whisper. Court is calling 2021 CR 4086, State of Texas versus Tyrone Shepherd. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Thomas Lane for Tyrone Shepherd.
Are you Tyrone Shepherd?
Yes, ma'am. Yes, Your Honor.
Counsel, have you received all the discovery in this case and did you review it with your client?
We were set today for a discovery hearing on some material that had not yet been produced. It was, I believe, not in the state's possession. I believe that issue is now moved and we're willing to move past it. Mr. Shepherd has decided to take a plea deal in this case.
All right, is that correct, Mr. Shepherd?
Yes, Your Honor.
All right, the court will find that the state is in compliance with discovery. Mr. Shepherd, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor. I did.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Are you proceeding with the deadly weapon allegation?
Well, Judge, I don't know. I didn't take it. Maybe.
Okay.
It's SBI or the deadly weapon.
It's SBI. I thought.
Okay, but it looks like we're proceeding with just the SBI, so it looks like we are waiving the deadly weapon allegation.
All right. Any objection?
No objections.
All right, Mr. Shepherd, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with aggravated assault, serious bodily injury as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine.
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case? Did you intend to give up those
I
rights?
intend to do that, but
No.
my attorney and I conferred this morning.
No,
and
my
that was
question, no.
that was-
Listen to my question. The rights that I've just gone over with you, do you understand them? The rights that I talked.
To have learned them in the past 2 hours, not fully.
Oh, well, let's do this. Do you understand that you have a right to have a jury trial?
Yes, I do understand.
All right. Do you understand that a jury trial would consist of 12 people sitting in this jury box?
Yes,
The state would present evidence to them through question and answer. Your attorney would have a chance to question and answer them. Question them. Do you understand that?
yes, Your Honor.
All right. Do you understand, because you're entering this plea agreement, that the state is not going to call any witnesses? Do you understand that?
I understand that. Your Honor.
Do you understand that your attorney then is not going to be questioning any witnesses because no witnesses are being called?
Yes, Your Honor.
All right. Did you understand that if you were going to jury trial? Thank you. Did you understand if you were going to jury trial that the state could not turn and say, we want to call Mr. Shepherd as a witness? Did you understand that?
Like I said, Your Honor, in the past 2 hours, all this has been thrown at me. So no, I
Time
haven't,
out.
but I understand it. I understand the things that you are saying to me right now. I
All
do
right.
understand
Awesome.
that.
So you understand
Yes.
that during a jury trial, the state couldn't call you as a witness. You understand that?
Yes, yes.
But because you're entering this plea, you can be called as a witness. You understand that? I'm not saying the state is going to call you as a witness, but when you enter a plea, you're giving up your right to remain silent. Do you understand?
Yes,
All
I was
right.
explain that.
All right.
Yes.
So do you understand all these rights I've given to you?
Yes, Your Honor.
All right. And you want to go forward with this plea?
Yes, Your Honor.
All right. Counsel, has your client been able to provide you with any defenses?
Yeah, yes, Judge,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Shepherd, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Has anyone forced you to do this? That's either yes or no. And let me explain something to you. Forcing somebody in a plea doesn't mean you're being forced because somebody tells you, well, if you don't accept the plea, then you have to go to jury trial. That's not force. So did anybody, other than telling you that, did anybody force you to enter this plea?
In a way, do I feel forced? I feel forced, yes, but no one has forced me. I do feel forced.
All right, you want to talk to him about why he feels forced off the record, or do you want to inquire?
I'm happy to speak to him off the record, Judge.
All right, I'll let you all speak off the record. Kelly Piddle, you have Diaz?
I do, Judge. I think he should be on Zoom.
He is.
Neat evaluation, right?
You need 6 months.
All right, could I have the file on Eric Diaz, please? Eric Diaz. No, I don't. And to those who have somebody who's in custody, you need to request them from the deputy and they will bring them out. Montoya? Yes. All right. Eric Diaz is by Zoom. All right, so what are we here for today?
Judge, we are set on Monday in impact court and I filed a sworn motion for continuance. And I'm asking the court to review it and potentially grant it.
Okay. Let me look at this. All right, we're going to go on the record. Court is calling 2023 CR 2918, State of Texas versus Eric Diaz. Can I have parties announced for the record for the state,
Zach Dunn for the state.
for the defense?
Kelly Piddle.
And are you Eric Diaz? I need you to unmute.
Yes, ma'am.
All right, your attorney has filed a motion for continuance. Everyone, please whisper. Your attorney has filed a motion for continuance. Are you okay with him filing this motion? Do you have any objections to this motion?
No,
All right, state, do you have any objection to the motion?
No, Your Honor.
All right, so defense, you're going to be out of town. Is that correct?
Yes.
How long are you all expecting this jury trial to last?
2 days.
I agree with that, Your Honor.
All right, I'm going to grant your motion for continuance. And the complainant is aware.
Yes, Your Honor. Yes.
Ms. Ferguson, what date can they come back? They're saying 2 days. So it's probably a day for jury selection and then a day for testimony. All right, your jury trial date is going to be January 16th. And Mr. Diaz, you'll need to appear in court. Do you understand?
yes, ma'am.
right.
Also, do I appear on the 4th as well? On the December the
No.
4th as well?
Now, you will appear on January 16th, not the 4th. You understand?
Okay, yes, ma'am.
All right, is there anything else?
To Judge.
All right, you're excused. Make sure your client knows to be here on that date.
I'll let him know, Judge.
Thank you, Judge.
All right, thank you. Oh, I'll disconnect him.
Yes, sir. I have.
Just give me a moment. Angel Montoya. Hello, where's Miss Montoya? Come up. Okay, why was she late for court?
Judge, that was my office's fault. We had a setting for a regular 9, I had a 10 o'clock and I had a 2 o'clock, and my paralegal got them switched.
Okay,
And then when we called your clerk to verify, it was verified that it was for 9 o'clock,
Mhm.
but we failed to tell her. So when I called her, she said, well, you emailed me for 2 o'clock.
okay.
It was our fault.
All right, so where are we on this case with regards to discovery?
Discovery's in fine order, Your Honor.
Okay.
And then, I think we've been discussing today, Ed and I, in terms of a potential reset for the reason of there was an eyewitness to this case, Your Honor, that is under the age of 18. We had made attempts to reach out to them and speak to them, but we had not been able to reach out to them or their parent. Today, actually, Ed was able to basically give us a chance to speak with them. So we have other pretrials today, Your Honor, so it might be a little difficult in the next couple minutes, but we would ask for just one final opportunity to speak with the eyewitnesses procured by defense.
He turns 18 on December 16th, so you wouldn't even need a parent at that point.
All right. So, Norma? We have somebody who's turning of age on what day?
December 16th.
December 16th. So can we bring this back on December 18th? And see if he is more than willing to come to court, and maybe everybody can talk to him while he's in court.
Oh, yeah, he'll be here.
Thank you, Judge.
All right, thank you.
We appreciate
All
it.
right.
All right. Once you sign the reset form.
Thank you.
Thanks again, Your Honor.
You're welcome, sure.
All right.
Great seeing you. Absolutely.
All right, is anybody ready on Carl Jones?
Yes, Judge, we are ready.
Okay. Carl Jones. So what I want to tell both of you all Veterans Treatment Court personnel, they had to do their staffing. So they came to give the court an update on whether or not he was accepted. My understanding, they had already talked to you about that.
Yes, ma'am.
So they were saying that they can't accept him because of information. And it's not anything negative on his part. It's just that he doesn't meet the criteria for their program here.
Yes, ma'am.
So what they're saying is their recommendation, which, you know, you all do your negotiation, was that he was to go to the, I think they said Temple Domiciliary or someplace. But they said, if you want to speak to them, you can come down to the court where they are to speak to them.
Okay.
So have you all been tendered an offer or anything of that nature?
No, we've kind of been waiting just on the Veterans Court, Judge.
All right. So
We come back on January 16th with my other two gentlemen,
yes. So, but
but I will reach out and find out what they're talking about, then talk to Mr. Garahan and let him know, hey, here's where they're recommending, and see if we can't wrap this up.
all right. So we'll come back. Norma, can you put this on January 16th?
Yes, ma'am.
All right, we'll come back on January 16th. And if you could, I'm not familiar with the Temple Domiciliary program, but it's through the veterans. It's under the veterans umbrella, but I've just not had any dealings
Never
with that.
heard of it, so I'll learn all I can.
All right. So once you sign the reset form, you're excused.
Yes, ma'am.
All
Thank
right,
you.
thank you. And it seems like Veterans Treatment Court is still willing to offer him referrals, but they just can't accept him in their program.
Thank you,
Right.
Judge.
Thank you.
You're welcome.
Yes.
All right. Anyone else who has someone who's in the box, if you're ready, let me know. Yes.
I believe we're ready to resume your report.
All right. So Mr. Shepherd. And then just which one is next?
Is that for the dismissal for that?
It's for the assault. and public
Okay,
safety.
just making sure.
Norman, this is who I
It
have.
should be, if you want to check the file number.
All right, we are back on the record in 2021 CR 4086, State of Texas versus Tyrone Leonard Shepherd. So where we left off, Mr. Shepherd, has anyone threatened you, coerced you, or forced you to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
True, Your Honor.
Are you satisfied? Yes or no?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $500 fine. State recommends deferred adjudication. They're taking into consideration 2021 CR 8392. There's to be restitution to Michael Barnes, BARNES, and the anger management course. Did you understand that to be the plea?
Yes.
Defense?
That's correct, Judge.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There were several motions to compel discovery that the court ruled upon, I believe.
Mhm.
Those are the only outstanding motions.
Outside the agreement, the state is asking that your deferred adjudication be for a cap of 4 years. There be a TAP evaluation, 150 hours of community service restitution, and no contact with Michael Barnes. Did you understand that those are recommendations from the state? Court does not have to follow those recommendations.
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence?
Our state exhibit number 1 with all attachments.
Any objection?
No objections.
Going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
And I briefly, Judge,
Yes.
another, I guess, condition of his probation was that he be allowed to transfer to Georgia, where his family is, and
Okay.
his support structure there.
All right. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, please, Judge.
Anything you wish to say on behalf of your client?
Yes, Judge, I would remind the court that Mr. Shepherd has already spent more than a year and a half in the Bear County Detention Center on a mental health hold. He received 0 treatment. While in the jail, he was eventually released, following a subsequent finding of competency by the magistrate court. He has never missed a court appointment. He has no prior criminal history. He is a veteran. The complaining witness was a veteran. This essentially is a mutual combat self-defense case. The question being reasonableness of the self-defense. For that reason, I would ask the court to give Mr. Shepherd 2 years deferred adjudication and require him to participate in mental health treatment the entire period.
All right, Mr. Shepherd, where in Atlanta? I'm sorry, where in Georgia?
I'm not too sure at the moment, Your Honor. I'm not too sure at the moment, Your Honor. My parents have not made the decision.
Okay, so here's the thing. Before I allow you a transfer to Georgia,
Can I?
I- yes.
And may I speak to that also? I spoke to his father. His father has informed me that they have a place for him in their home. They have several acres and a home for him to stay in.
but where in Georgia? I still don't know that answer.
It would be in Brinson. Brinson.
How do you spell that?
Brinson.
And what county is that? Does anybody know? Any objections to me Googling? We'll see if Google knows.
No objections.
Oh, it's Decatur County. Okay. According to this, if it turns out it's not Decatur County and they're wrong, you need to let probation know.
Yes, ma'am.
All right, the court is going to sentence you to 3 years deferred adjudication. There's to be no contact with and restitution to Michael Barnes. Do you have any children? Yes, you.
I support 2 kids.
What are their ages?
One is 5 and the other is 2.
All right. I'll allow transfer to Georgia and Decatur County. And Ms. Abrams, Google tells me that Brinson is in Decatur County. If it turns out it's not in Decatur, let me know. There's to be regular reporting by Zoom or in person, regular UAs. Let's see. All right, and I want him to get in contact with Decatur with their mental health department. So I'll just say Mick, but I know it's not going to be Mick here once he's transferred. Yes. All right, so you to follow through on mental health treatment. And Decatur County, Georgia. And you're to follow up with the veterans, with the VA. And proof of employment or SSI within 45 days of transfer. There's to be no employment as a home health care provider or with minors. 150 hours community service restitution. I'm going to require parenting classes. Once that's complete, the community service hours will be deemed satisfied. Probation, is there anything else he needs?
Your Honor, between the mental health indicator and the proof of employment, you said something and I didn't quite catch it.
He's to make contact with a veterans treatment organization there. And I don't know if they have that. I just learned about this place called, well, this division under veterans treatment called Temple Domiciliary. I don't know if they have that there, but if they do, under that umbrella, they do take care of mental health. So you'll need to check into that, or your attorney can check into that for you.
Yes, Your Honor.
Anything else?
Your Honor, I just want to make it clear that although there is permission to transfer to Georgia, that he is to remain in Texas, in Bexar County until the transfer is accepted, and that could take anywhere from 30 to 60 days.
All right, so you're not to leave Bexar County until you're actually officially transferred to Decatur, Georgia. You understand?
That's cool, Your Honor.
All right. Is it cool? But do you understand?
I understand it, Your Honor.
All right, thank you.
I believe he's also currently under monitor GPS.
All right,
how
so-
does that be removed?
Once he's transferred to Georgia, the GPS can be removed. There'll be removal of GPS upon transfer.
So he's on GPS with pretrial right now.
Mhm.
It's a totally different thing. We would need a condition for GPS for this, and then
All right, so here's the issue with GPS. GPS will not allow for that device to be paid for. So is he able to pay for GPS monitoring or no?
I'm unsure, Judge.
Are you able to afford to pay for GPS?
Not at the moment, Your Honor.
All right. So if there's no objection to removing it in lieu of the GPS, I can have him call into probation weekly. Is everybody okay with that?
No objection, mistake.
All right, so we'll remove GPS. And he is to contact probation weekly until transfer. And if for some reason Georgia decides not to accept him, y'all can come back and I'll see what we're doing with the weekly reporting.
yes, Judge.
All right, is there anything else he needs? Is there anything else you need from the court to be successful?
No, Your Honor.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. We can go off the record. If you want to go to Veterans Treatment Court and find out where they're having their staffing, they would probably be able to help him get in contact with whoever he needs to be in contact with Georgia. So there's a seamless transition.
Do you happen to know where Veterans Treatment Court is?
All right, does anyone know where the location of Veterans Treatment Court, what floor?
No, it's 186.
186.
That's the second floor.
Just a second, I'm going through these conditions with the.
All right, so she'll confirm.
That's the third.
Thank you very much, Judge.
All right, you're welcome.
That's the third.
Judge, sorry to interrupt. You don't happen to have the paperwork on David Hernandez?
Let me see.
186 on 34. 186.
Third floor on the right.
Judge Escalante.
Thanks, sir.
No, I think they may still have it.
You guys don't have the paperwork.
I could have had a VA.
All right, can I see the parties on Lavario? Thank you. And this is no application. Court is calling 2023 CR 7675. State of Texas versus Matthew Randall Sanchez Lavario. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Hood
All right, and are you Mr. Lavario Jr.?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lavario, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the enhancement paragraph.
Any objection?
No objection, Your Honor.
Mr. Lavario, I'm showing you, excuse me. What's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with offense of aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right, off the record for a moment. Deputy Lord, could you move Mr. Cox and his client on that end? Is that possible? All right, we're back on the record. Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that by entering this plea, you were giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes,
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Lavario, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishments be assessed at 2 years in the prison. There's a $1,500 fine, affirmative finding of deadly weapon, affirmative finding of family violence. There's to be no harmful or injurious contact with Matthew Lavario. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes.
Did you understand that to be the plea?
Yes.
Defense?
Yes, Judge.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There were none, Judge.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Okay.
State any evidence?
Yes, Your Honor. State exhibit number 1 with all the attachments.
Any objections?
Objection.
All right, and state, have you had a chance to speak with the complainant?
I believe the complainant had not been contacted for this case. Your Honor.
All right, thank you. Mr. Lavario, I'm showing you what's in, oh, you may continue to confer.
Thanks,
Mr.
ma'am.
Lavario, showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits one and attachments, the court will find there is sufficient evidence to find the defendant guilty. Counsel, I have a problem with the no harmful or injurious contact with Matthew Lavario. So is that a sticking point for everybody? Because it seems that based upon what I'm reading, maybe he shouldn't be at that house though. I mean, I understand.
The father has, well,
I mean,
he has no objection to that.
all right, but you understand my concern?
After that, no.
Okay. Oh, well, because I mean, it's saying that his father, he struck him with a machete
I understand.
on the ankle
I understand.
and it went to the bone. So I'm just trying to figure out why is there a,
That was the initial report. I agree with that.
okay,
However, as the whole thing developed, that's why we're here on this plea. It turned out to be somewhat less than it was explained in that report. It still happened.
Mhm.
The father has no objection. We had no objection with him living there pretty. So it's not a problem for the father.
okay, I understand there's not a problem for him, but I have a slight problem.
Okay.
So is there an issue or something that was discovered after that I'm not aware of? I mean, if there was, if somebody can let me know.
Anna Ochoa Nelson for the state judge.
Yes.
We did receive an affidavit of non-prosecution from the victim in the case who claims that it was some kind of lawn accident. They were cleaning trees, that he did not want the case to proceed forward, Judge.
Okay. All right, that clears things up for me.
Yes,
I
ma'am.
need to have that cleared up because otherwise,
I didn't want to talk to the prosecutor on it.
all right, no problem. All right. The court will sentence you, as previously stated, the court is finding you guilty. Court will sentence you to 2 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's been no harmful or injurious contact with Matthew Lavario. Is there some type of mental health or issues with alcohol with your client?
Not that I'm aware of, Judge.
All right. Do you have any issues with alcohol or anything of that nature, drug use? If you do, I can request the therapeutic community for you at the prison. Whether you get in the therapeutic community or not will be completely up to the prison because I have no jurisdiction to force them to do that. But if you would like that, it does not increase the length of time that you are in custody. But if you need it, now's the time to say it and to perhaps get it. No? Okay. All right. Is there anything else with regards to sentencing?
Nothing for we've said since you followed the plea agreement. Judge.
All right. So did you review the document entitled Trial Court Certification of Defendant's Rights? With your attorney, did you understand it?
Yes.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence and also a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. How old are you?
36.
All right, I'm going to tell you this. Usually, people only get one parent in their life. I'm going by what happened from the police report and what everybody's telling me. But you know what happened? Your father knows what happened. What I know is if you're going to be living with your father, you need to be respectful to your father. If you feel like your father is not being respectful to you, then you need to get your own place. Do you understand?
Yes.
All right, good luck to you. Thank you.
You excused, Your Honor?
Yes. Trayvon Stevenson. No, I'm being asked that he be called up. And then after Trayvon Stevenson, it's going to be Martin Carrion. I'm sorry, that goes in the file. No, is there an issue?
No, Judge, I just, Mr. Stevenson had questions and wanted to reiterate what the court wanted in regards to how everything's gonna work out. So I was explaining to him that the felony drug court will They will evaluate him first.
Mhm.
If he's not accepted into felony drug court, he will be evaluated by SATIV.
Yes.
At that point, if he's in SATIV, if there is a letter from the military indicating he's going to go back into the military, at that point, we would present it to the court for his release from SATIV.
Yes.
However, in the meantime, in additional, we are having a TAP evaluation being done in custody. Now, when the TAP is done and the felony drug court referral goes through, all of that should just fall like in place.
Yes.
Is that correct?
Yes, that's correct.
Do you
Do
understand?
you understand? You have any questions about anything?
Will I be getting time served for any time that I sit in Bear County?
Well, you're not going to prison, so there's no need for any credit for any time served. But if for some reason you're on probation and you get revoked, yeah, you'll get credit for any time served. Okay. All right. Thank you.
Thank you, Judge.
Martin, carry on. And there's no application. Court is calling 2023 CR 9561, State of Texas versus Martin, carry on. All right, just 1 second. And Deputy Laura, if you can move them. We're on the record. Could I have parties announced for the record for the state
Jason Garahan, Your Honor.
defense?
A lot of ways for the defense.
And are you Martin Carry On?
I am, Your Honor.
Counsel, have you reviewed all the discovery with your client and did you receive all discovery?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Carry On, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney?
Yes,
Did you understand it?
I did, I have, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Any objection?
No objection, sir.
Mr. Carry On, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of evading arrest, detention, and vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
I do, Your Honor.
All right, off the record, he needs to check whether or not he's a citizen. Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea? If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
I do, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Sure.
Did you intend to give up those rights and enter into a plea in this court?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
You have, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Carry On, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Absolutely, Your Honor.
Are you a U.S. citizen?
I am, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
I have, Your Honor.
According to the plea, punishment is to be assessed at 5 years in the prison. There are no applications. The state is taking in consideration 722-427, 716-489, 716-490, 716-491. Did you understand that to be the plea?
I have, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor. Sorry.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence?
Yeah, state exhibit number 1 with all the attachments, Your Honor.
No objection, Judge, for purpose of the plea.
All right, states you may be excused. Going to show you what's entitled waivering consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
I have, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just that the court follow the agreement.
All right, the court will follow your agreement, find you guilty, sentence you to 5 years in the prison, give you credit for any time served, taking consideration 722-427, 716-489, 716-490, and 716-491. Is there anything else with regards to sentencing?
No, Your Honor.
I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor, I have.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
I do, Your Honor.
All right, we can go off the record. How old are you?
I'm 43, Your Honor.
It's time to stop the foolishness, because otherwise you're going to end up at the prison as a habitual. And if you have another felony case and you're labeled a habitual, depending on the type of felony, your minimum is 25 years in prison. Do you understand?
I do, Your Honor.
Do you have any children?
I do, Your Honor.
What are their ages?
I have 7 children. They range from 27 all the way to 15.
15-year-old is not receiving guidance from you. Maybe that's a good thing, maybe not. But if you want to be in their life, you're going to have to be better. You understand?
I do, Your Honor.
All right, good luck to you.
Thank you, Your Honor.
You're welcome.
Thank you, Judge. May I be excused?
Dinah, let me know whenever you need a break. You want a break? All right, yes. All right, everyone, we're going to take a short break so the court reporter can exercise her fingers a little bit.
Oh, you do.
And then after that, what will be coming up next is going to be Johnny Joe Webb and Sebastian Delgado. And those are the only files that the court has that are ready. Norma, I'm gonna go grab some water for myself. Luis Henry? Yes. All right, so what is happening with this case? Is this going to trial?
Guess we need a trial setting judge. About the only reason that we wouldn't would be that there are three unindicted other cases. But you know, that's been the case ever since I've been on it. So it seems to me putting this on the trial docket is going to make us one step closer to resolution.
All right, state, how long do you expect this trial to last?
Oh, maybe.
Maybe.
Okay. Let me see if I can find him on the docket.
He's on page 13, Judge.
All right, thank you. All right. So this is going to jury trial then. Court is not going to consider any plea bargaining agreements without good cause. Otherwise, you're going to have to plead open to the court. Do you understand?
Yes.
All right, when do y'all want this set?
Judge, this is just.
You want to put it in December or?
Just as, I think, next week's a little busy.
Okay,
January 9th is fine with the state.
All right.
Fine with the
Fine with me, Judge.
all right, so you'll be going to trial January 9th.
Thank you, Judge.
Thank you,
All right,
Your Honor.
you're welcome.
Just have a seat.
Who is here on Johnny Joe Webb?
Hey, Your Honor.
And this is an application for probation.
Yes, ma'am.
Court is calling 2023 CR 9819 State of Texas versus Johnny Joe Webb. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Matt Stolhansky for Mr. Webb.
And are you Johnny Joe Webb?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor, I did.
Court will find that the state is in compliance with discovery. Mr. Webb, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, there's two cases, just.
Oh, there is?
Yes.
Yes, ma'am.
Okay, let me see. Thank you.
Slow you down there.
A fraud case and it should be a possession case, Your Honor. There's 4 cases total presented in front of you, 2 are the details.
Ah, thank you. And the court is also calling 2023 CR 0549. And again, and that cause number, counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
And that cause number, the court will find that the state is in compliance with discovery. And in that cause number, did you sign and review with your attorney the application for community supervision?
Yes, ma'am.
Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State in that cause number, you're proceeding on the indictment as presented?
On the 2023 CR 0549, yes, that indictment as presented. Your Honor.
All right, and then in cause number 2023 CR 9819, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on count 1 alone, waiving count 2 and 3.
Any objection?
No objection, Your Honor.
And each cause number, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am, I did.
And the cause number ending in 9819, you're charged with fraudulent use or possession of identifying information 50 plus items. That's a first degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. And the cause number ending in 0549, you're charged with the offense of possession of a controlled substance. Penalty group 1 gram to 4 grams. That's a third degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
And each cause number, if you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand in each cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand in each of these cause numbers by entering into plea bargain agreements, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, ma'am, I did.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes, sure.
In each cause number, do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, ma'am.
And each cause number, do you believe he's currently competent and was legally sane at the time of the offense?
Absolutely, so, Your Honor.
Mr. Webb, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number showing you the plea bargain page. Did you review that page with your attorney?
Yes,
Did
ma'am.
you understand it?
Yes, ma'am, I did, I'm sorry.
And each cause number, the plea is for punishment be assessed at 6 years in the prison. There's a $1,500 fine. State is silent on your applications. There are several cases that are being taken into consideration. There's to be restitution in cause 9819 to the complainants. And in cause 0549, there's to be restitution to SAPD for laboratory testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
And each cause number, I'm showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then in cause number ending in 9819 to count one, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And in the cause number ending in 0549, how do you plead? Guilty, not guilty, or no contest?
Guilty.
All right, so guys, everyone, when you have somebody who's in the box, please don't talk behind the court reporter, just ask and they'll take you to the other end. And the cause number ending in 0549, how do you plead? Guilty, not guilty, or no contest?
Guilty.
All right, state any evidence.
Yes, Your Honor. Each of the cause numbers, state exhibit number 1 with office attachments.
Any objection?
No, Your Honor, I've reviewed with my client. We have no objection on both cases.
All right, in each cause number, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review those documents? Do you have anything for me to sign?
No, Judge.
Okay, did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Oh, and you may be excused. Thank you. Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, and each cause number, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Ms. Ferguson, I need a date, return date for PSI and TAP. No problem. All right, we're going to come back on January 25th. On January 25th, I will let you know whether or not I'm going to grant your application. That decision will be based upon the PSI report and any of the evidence that's submitted to me. Do you understand?
Yes, ma'am.
All right, so if you make sure you make all of your appointments, and if you will get a reset form, you're excused, and then you'll need to speak with probation.
Okay.
All right, thank you.
Thank you, Your Honor. Am I dismissed?
Yes.
I'm sorry.
All right, who's here on Sebastian Delgado?
I am, Judge. We're ready.
All right, court is calling 2023, and counsel, you're on this side. Counsel. Court is calling 2023 CR 9521, State of Texas versus Sebastian Delgado. Can I have parties announced for the record for the state,
Jason Garahan, Your Honor.
for the defense?
David A. Garcia, attorney for Sebastian Delgado.
And are you Sebastian Delgado?
Yes, Your Honor.
Counsel, have you received all the discovery, and did you review it with your client?
I have, and we have, Judge.
Court will find that the state is in compliance with discovery. Mr. Delgado, I'm going to show you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it, and did you sign it? I'm going to show you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
All right, and probation, this is an application.
Thank you, Judge.
All right, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison
Yes, Your Honor.
and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is.
Mr. Delgado, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $500 fine. State recommends deferred adjudication. They're taking in consideration 700,389. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, have there been any such motions?
There you go.
Outside the agreement, state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 150 hours community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Right, then to the offense is charged. How do you plead? Guilty, not guilty, or no contest?
Contest.
State any evidence?
Yes, Your Honor. Sitting exhibit number 1 was all suppressed.
We reviewed states one and all attachments, Your Honor. We have no objections.
All right, state you may be excused. I'm going to show you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, he made a mistake. He knows he made a mistake. He's looking to prove himself to the court, and we're hoping that he follow the plea bargain.
All right, Mr. Delgado, do you have any children? All right, how old are you?
18.
All right. Is this your first charge?
Battalion, Judge.
All right, what other charges do you have that were done? Misdemeanor what?
For marijuana. That's the one that's being taken into consideration, Judge.
All right, let's go off the record for a moment.
Oh, yeah, it's on the hearing. Well, I don't know if we need to talk about that. That's fine.
Oh, thank you so much. My allergies are killing me.
Yeah.
All right, can we take up Rogelio Sanchez before we do this? All right, where's-
For a reset on.
Oh, okay.
Yeah. And Judge,
Yeah, we're here.
sorry, Judge. Maybe
Oh, no. We'll take this up and then, where's Mr. Cox? If you all let him know, we'll take up Mr. Sanchez next.
He's on the phone. Let's hit him up.
Okay. All right,
Comments?
Joe Anthony Thomas, come down, please. All right, what is happening with this?
Judge, there's some nightmare cases, Agasol, that just happened in October, and then two other cases associated with that one.
Mhm.
I know this is NTR, but we haven't even been able to look at any discovery or anything on that Agasol. We're asking for a reset.
And I'll
Okay,
say
but-
also, I'm in the process of investigating. We're desperately trying to get a hold of some videos that we think might exist. And so far, we keep running into dead end after dead end, but the defense is working diligently as well.
Okay, so how much time are you all asking for?
30 days, Your Honor.
All right,
Yes,
Ms. Ferguson, can you recall this in January?
Yes, ma'am, January 4th.
Fourth,
All right, January 4th, and your next date after that date is going to be a contested hearing.
yes, Judge.
All right,
We can find. Yeah. You're good to go. All right, text me, you know how to read.
Yes.
Thank you.
all right, and then, Mr. Cox, you ready? Court's calling 2020 CR 10450, State of Texas versus Rogelio Sanchez. Can I have parties announced for the record for the state
Jason Garahan, Your Honor.
defense?
Bridget was here, she had to go down to 186.
All right, and I'll note she's the second chair, correct? Any objection to proceeding without Ms. Garza?
No objection.
Any objection from the state? Any objection from you, Mr. Sanchez?
No.
All right, counsel, have you received all the discovery and did you review it with your client?
Yes, sir.
Court will find that the state is in compliance with discovery. Mr. Sanchez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, sir.
State, are you proceeding on the indictment as presented?
No, Your Honor. One, we're waiving the routine enhancement paragraph. Okay. We're waiving the repeater enhancement paragraph, Your Honor, and then also reducing to the lesser included offense of murder, first degree.
Any objection?
Okay.
I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
You understand, the state is proceeding on the lesser included offense of murder. That's a first degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes.
Did you understand by entering this plea, you're giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, sir.
Do you believe he's currently competent, was legally sane at the time of this offense?
Yes, sir.
Mr. Sanchez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on murder. Your punishment is to be assessed at 25 years in the prison. There's an affirmative finding of a deadly weapon. There are no applications. The state will take in consideration 2020 CR 10474A. Did you understand that to be the plea?
Yes.
Defense?
Yes, sir.
State?
It is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counselor, there been any such motions?
Oh, yes.
Then to the offense of murder, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. State exhibit number 1 with all of its attachments.
Okay.
Going to show you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will find you guilty. Are we proceeding with sentencing?
State's ready to proceed, Your Honor.
Anything you wish to say on behalf of your client?
Just let the court follow the agreement.
All right, the court will sentence you to 25 years in the prison, give you credit for any time served. Take in consideration 2020 CR 10474A. There's an affirmative finding of a deadly weapon. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. Thank you, Mr. Cox.
Your Honor, we do have just a reading of a victim impact.
All right, so there's a victim impact.
Yes,
Who's to read the victim impact?
but the advocate Rose, Perez.
Okay,
Would you like to proceed, Your Honor?
yes.
I doubt that whatever we say will have any kind of impact on you. But your action on June 28th, 2020 and July 4th, 2020 will forever have an impact in Adrian's, Veda's, and in the lives of all of us, family and friends who loved him. We have been diligently watching every single hearing since the very first one, patiently waiting for justice to be served. It's been more than 3 years now. We're not sure of what will happen today. Will be justice. The state of Texas presented you with a plea deal, and of course you decided to take it. We wish Adrian would have had a saying in the matter and what happened to him. He had no voice, he had no one to talk to on his behalf, he had no counsel. For him, you imposed yourself as the ultimate authority. He had none of the privileges you are taking fully advantage of today. He had everything taken away from him that day, even the ultimate dignity of resting in peace near his loved ones who passed before him. We know that the words you hear today mean nothing. No human being capable of your actions are fertile ground to actually listen or care about anybody. Hear this. Adrian's life mattered. He had great loving parents who adored him since the moment he was born. He had family and friends who supported him and loved him until that terrible day, the day you and him crossed paths. We feel comfort knowing he is with his beloved parents right now. We don't need you to know we don't need to know you, to know your life, had none of the same experiences. I think the ultimate penance for you would be to continue living your life in the path you forged for yourself. To live carrying the badge of honor of the crimes you've committed. You can't hide or run from who you are and the sufferings you've caused to others. Whatever your plea will today, you know that your life sentence will be to live in your own skin. You took Adrian to prevent them from us, but you didn't take the life we experienced together, nor the love and place you will forever have in our family.
Thank you.
Thank you, Judge.
Thank you. All right, on Delgado, are you all ready to come back on Sebastian Delgado? Yes.
It's gonna be a withdrawal.
All right.
Oh.
Okay, you would, oh, she's out in the hallway? Huh? Okay.
Yeah, you wait, check.
Oh, did you see if Dinah is in the hallway? Thank you. Norma, on Sebastian Delgado, I'm gonna need a date for PTD.
Your turn. I can do one week.
All right, so we're gonna come back on January 8th on your case. Between now and then, let me just tell you what you probably need to do, because I think if I were to drug test you today, you're probably gonna be positive for marijuana. You understand? So you need to stop hanging around people who are not bringing goodness into your life. I know a lot of young people think, it's just marijuana or it's just this, where you're on a track in your life, you're 18, you still have more of your life in front of you than behind you. You're getting this chance to do a pretrial diversion. So stop smoking marijuana. You understand? Stop hanging out with the person that you were with when this happened. Just go to work and go home. That's it. Are you still living with your parents?
Yes, John.
All right, so go to work and go home. That's it. If you do that, you won't get into any trouble. All right, we're going to go back on the record in 2023 CR 9521, State of Texas versus Sebastian Delgado. My understanding is defense, you're asking that the plea be withdrawn?
That is correct, Judge.
Any objection?
No, Your Honor.
All right, so the court will allow the withdrawal of the plea. We're going to come back on January 8th to see where we stand with PTD. State, if you want to get with the clerk to see about removing the steps, or if y'all can print them out again, however you want to do
We
that.
can always print them out again, so
Okay.
there's no need.
All right,
Thank you, Judge.
you're welcome. Moses Ross. Hello.
Good afternoon, Judge.
Oh, good afternoon. All right, are you all ready?
Yes, ma'am, we worked it out.
All right, so court is calling 2023 CR 3543, State of Texas versus Moses Ross. Can I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense?
Roy Barrera, Jr.
Are you Moses Ross?
Yes, ma'am.
All right, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
I believe we got it last time, yes, ma'am.
Well, no, my question is, did you review it with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
All right, are you the same Moses Ross who was placed on deferred adjudication in 2023
Yes.
CR 3543 for the offense of assault, bodily injury, married family on August 24th, 2023 for a period of 1 year? Is that you?
Yes, ma'am.
All right, state.
Your Honor. On or about the 27th day of September 2023, in Bexar County, Texas, the defendant, Moses Ross, did then and there fail to register for and attend battering intervention and prevention program with an approved agency in violation of condition number 18.
How do you plead to that? True or not true?
True.
State,
Your Honor, the state waives and abandons the other conditions.
any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 18, the court could find it true, grant the motion, find you guilty, sentence you to 1 year in the Bear County Jail and up to a $4,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation 18?
Yes, ma'am.
Court will find violation of 18 true. Is there a proposed agreement?
Yes, Your Honor. The proposal, when in conferring with counsel, Your Honor, would be to revoke and adjudicate via a judgment satisfied in an affirmative finding of family violence, Your Honor.
And how much time are you all requesting?
It would be there's 13 days served, Your Honor. The underlying probation is for a Class A misdemeanor. And so the state confirmed that, yeah, there's 13 days credit. And that was the proposed agreement, if you will, between state and defense.
Correct, Judge.
All right, so here's my question. What has he done on probation? It appears that the main thing that needs to be done when you're on for assault is the BIPP course. So has that been completed?
No, ma'am, but I could tell you what happened.
Sure, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, then nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Moses Ross. When I got put on probation, I went back to jail, and that was the time that I was supposed to sign up for my bibs. During the time
Wait a minute, that was supposed to be the time you
that
did.
was the time that I was supposed to sign up for my bibs course.
Mhm.
But I was in jail. And then when I got back out of jail, I got put on a monitor, on the ankle monitor. She's very difficult. I made an appointment to go. She approved it. I went and they said to bibs. They said that I needed my court paperwork and $25, which I was unaware of. So I didn't get to sign up that day. Before, you know, I told you last time I said, well, can I fix what I've done wrong? And you said, you do whatever you want.
Yes.
When I made an appointment last week and I sent her all the proof and the appointment stuff. And she says, well, you're not telling me soon enough. So what don't you understand about you having to tell me if I could go or not? And bib classes pushed back a week or 2 weeks every time. So they had someone that dropped out. I got that appointment. I went to my PO, my probation officer, excuse me. And I got my paperwork for court and I had the $25. I made 25 each time. I made my appointment. I sent her the information and she didn't let me go to the course. I've tried several times to go to the course and there's nothing that I'm not like avoiding the course because of anything. It's just the monitor really, it messes with my school. I'm still in school. I quit my job because my manager didn't want to continue to print on my schedule every week for my officer. The officer.
Okay, well, what I can tell you is I'm not the person who placed you on probation. Somebody else did. I don't think that revoking him, he's only been on probation since August. So that's September, October, November, 3 months probation on an assault case. I'm not going to give him a judgment satisfied for that. I want him to complete the bib course. After he completes the bib course, if people want to come back to me and see if I would consider early termination, then of course I would consider that.
Okay.
But for me, the main thing on an assault family violence case is you complete the bib course. And there are consequences to a revocation and a guilty plea on an entering of guilt in the judgment from the court on these assault cases.
I agree with everything you're saying. My question is this. Would you consider, so he's a professional barber. Would you consider so that he can do his bit, get a job, get employed, pay probation, would you consider removing his monitor so that he can resume working, going to school and doing it?
I would consider tracking, but I will not consider removing the monitor unless somebody tells me the complainant is aware that the monitor is being removed and the complainant feels safe with the monitor being removed. And the reason why, you can unfold your hands. All right. People always would tell me in class that when you fold your hands, that means that you're upset or it means that you're closing yourself to information that's being delivered.
That's funny.
And sometimes I do this and I'm like, I'm not closed off. But my professor would always say, that means you're closed off. So you're supposed to be open to receiving.
Receiving.
Yes. So people will always say that when you're a judge, you're not supposed to express yourself on the record because if you do, and you were a judge, so you know, they say as little as possible. But I'm a firm believer that communication is key. And I don't like for people to think that I'm just doing something because I can. So the reason why I'm looking at tracking is because, one, I don't have any information from the complainant saying that they're not in fear. I don't have any information from the complainant saying that the complainant is aware of what's going on here today. And even if I were to give you a judgment satisfied, that's another concern, because part of my duties as a judge, when it's in my purview, even that's okay. Even when I'm setting bond conditions, I got to make sure that the public is protected, right? So, and let me get some update from probation. All right. And they say, she's telling me that there's an issue, the monitor, it's pretrial service issue. Norma, can you get the pretrial services officer to zoom in?
Do you need your pretrial service?
Is the issue?
No, we're trying to find out what the issue is. See, we're trying to get everybody on the same page to communicate. So who is the person you report to with the monitor? What's her name?
Parvo, Ms. Parvo, CHA, Shay, Parvo. I have it on my emails.
Yes. If you will give that to the court coordinator, and we'll get them to zoom in, and that way everybody will be on the same page.
Even
Oh,
tracking would be amazing too.
No. Just give the information to the court coordinator.
He can call the person.
And so if you all will just wait,
Okay.
and we will take that up, and that way communication is key. Are we ready on Renee Cantu?
Yes, we are.
Okay. Oh, and hello.
Actually out of the office itself.
All right, your signature is not on this. Thank you. Just 1 second, I opened up the wrong file. Why does it keep?
Yeah.
Just give me one moment. All right, before we go on the record, what is this case out of Edwards County? Have you had a chance to review the
Yes,
PSR?
I have completely.
What is the awaiting hearing on that? Is that still a waiting
He has
hearing?
a plea bargain that he'll be entering on January the 8th with 3 years probation.
Okay,
January the 8th, 2024.
okay. And if your client is drug tested today, what are the results going to be
Positive.
for? Okay. All right, court is calling 2022 CR 11790, State of Texas versus Renee Cantu. Can I have parties announced for the record for the state?
Jason Gearhead, Your Honor.
Defense?
Lloyd Burrell Jr.
All right, and are you Mr. Cantu?
I am, yes, ma'am.
All right, you entered a plea of no contest on October 11th. The state waived count 1. They proceeded on count 2 only. You applied for deferred adjudication. According to the plea bargain agreement, punishment must be assessed at 4 years in the prison, and the state is remaining silent on your application. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense? Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
All right. Anything you wish to say on behalf of your client? And I think the first thing that needs to be addressed from the court standpoint is the acknowledgement or guilt or not acknowledgement of guilt that it says in there.
Right.
All right, so yes, the state is silent, so you may begin, counsel.
Regarding his acknowledgement and acceptance of responsibility, he unequivocally accepts responsibility for that behavior that he's performing today. Number 1. Number 2, he is willing to accept the fact that he has issues regarding drugs and the use of drugs. He has, needless to say, been in denial for most, if not all of his life, that he does not. The fact of the matter is, Judge, that he lost his father to prison when he was 2 years of age. He's now 32. His father is still in prison to this day. He lost his mother to a drug overdose, and he was raised by CPS. He has never had a psychological evaluation in his life. He has never been on medication for any of the issues that were caused by abandonment and by basically roaming the country. He wants to change his life. As the pre-sentence investigation said, he is, I think they use the term, he's just about there to accept responsibility and to receive and accept help. If you should place him on probation, Judge, I'm asking that you order a psych eval, because I do believe that my client is suffering from illnesses that have never, ever been treated or been diagnosed.
But you believe he's competent?
Absolutely.
Okay.
No doubt. My client is an intelligent person. For the very, very weak and almost non-existent formal education he's received, he's, I find him to be way beyond his educational years as far as his intellect. So he stands before you asking you to consider his applications, either one, as the court may see fit, but that he brought some documents as proof that he's not a loser, and that he has done things to his credit, which I'll ask him to mention to the court if that's possible.
Yes, and I can tell you this, everybody who appears before me,
Mhm.
and what they've done I never consider anybody a loser or anybody a throwaway. Some people have made bad decisions in their life and there are consequences for that, but I don't see people as losers.
Right.
All right, yes.
Good afternoon, first of all.
Good afternoon.
So, Your Honor, I had a messed up childhood, period. I was in CPS since I was 9 years old. If you only knew the amount of stuff in CPS that happens. So
I do.
So of course I had a totally messed up childhood. I'm not making an excuse for that, but as I grew up, little by little, of course, I was crazy. I was stupid doing
Okay,
everything.
and let me stop you for a little bit because I need to swear you in. Can you raise your right hand for me? Do you solemnly swear affirm testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand and you can continue.
Okay, so yeah, as I grew up, I was wild. I was stupid, you know, making a lot of crazy decisions. So yes, I did mess up. I still have cases that are pending or whatever.
Mhm.
All that is by one specific officer. It's not like I messed up and messed up and messed up. No, it's all by one specific gentleman. He just put different warrants. But since then, I used to live with somebody. Now I have my own house. I have a copy of my whole lease. I have all of my check stubs from my employment. I even have business cards now. I'm a certified mortgage inspector.
Okay.
All the bond I paid 14,000 total in bond. Good. I don't owe anything else. I paid pre-trial in full. I actually have a credit on pre-trial. So I'm good now. Like I have everything going for myself now. Back then, of course, I was stupid. I'm like, okay, come on, you know. But dude, now I have everything that I have going. Do you get what I'm saying?
I get what you're saying, but you want to know if I'm catching what you're saying.
Are you catching what I'm saying?
Yes, I am. I caught it.
So I admit I need help. Help, like therapy. Yeah, that's the help I need. I don't need help going to prison.
Nobody thinks they need to go to prison, though.
You know? Yes, ma'am. You're right.
Even people who commit murder, they will always say, I don't need to go to prison for murder.
Yeah, but therapy, like I want help me out with my head. You get what I'm saying?
Mhm.
But yeah, that's all I ask. Thank you, by the way. Thank you for everything, every time.
Okay. Any questions? All right. So you're over 30.
Yes, ma'am. Correct.
32.
32. I'm going to tell you what I would always tell people that I would represent in Child Protective Services, because I know the government is not in the business of raising children. And 9 times out of 10, the government doesn't do well at raising children. Parents are supposed to be raising their children and they're not. But I'm going to tell you this. Every tub got to sit on its own bottom. You know what that means?
Not really.
All right. Let me tell you what that means, because my grandmother would say that to us all the time. This is what it means. At some point, your bad life that your parents gave you or that somebody else gave you, you can no longer blame it on them. At some point, you sit on your own bottom.
Correct.
Imagine yourself a tub. You got to sit on your own bottom. So at some point, the decisions you are making, you can't say, I'm making these decisions because of my childhood, because you are now in your 30s.
Yes.
And you know what the law is. You know what you should not be doing.
Yes.
So you're going to have to stop doing that.
Yes, ma'am.
For example, you need to start being negative for all drugs.
Yes.
Unless it's a prescription, you shouldn't be turning up positive for it.
Yes,
If
ma'am.
you do, you're not doing well. You
Yes, ma'am.
understand?
Yes, ma'am.
So you're coming to me, asking me to grant you probation or either deferred adjudication, correct?
Yes, ma'am.
Do you want to go to prison?
No, ma'am.
All right. So if I were to grant you deferred adjudication, you're looking at the full range of prison if you mess up on it.
Correct.
If I were to grant you regular probation, the most I could sentence you to if you were to mess up would be 4 years. So I'm going to give you the treatment that you say you need, but right now I'm going to give you a choice. Here's your choice. I can grant your application for deferred adjudication. The good thing about deferred adjudication is It's not a conviction on your record, but anybody will be able to see that you are on deferred adjudication for this.
Correct.
Now, if I grant that and you are unsuccessful, then you're potentially looking at 20 years in prison.
Correct.
Or you can have a conviction. If I give you a conviction and you mess up on it, the most I could sentence you to would be 4 years in the prison. You're saying yes, so which would you prefer?
The latter, please.
What, the
The
4
second one.
years?
Yes, ma'am. That's with the probation.
That's
If
where
I
you have a
mess up-
conviction, and if you mess up, the most you could get is 4 years. But there are issues that come with a conviction, and I'm sure your attorney can tell you that. So you want to talk to him about whether he,
We have already discussed
So-
the difference, and Your Honor, that's why I left it up to you and I said, obviously it's your decision, but in the event that you did not grant deferral, of course, he wanted to ask you for probation. And,
oh no, sometimes I give people choices.
as today, his choice would be, and we discussed it, is straight probation.
Okay.
Correct, Your Honor. No.
Will that affect your job? Are you licensed by the state?
Correct, yes.
Will it not affect your job if you're licensed by the state?
Mhm.
You may need to have deferred.
No, jobs are so easy to come by now. If you want something, you're gonna get it.
Okay, well, you tell people, jobs are so easy to come by, everybody. So when people come in here saying they can't find employment, they're
That's an
just not
excuse.
looking. That's
Go be a go-getter. That's how I've been. Go get a damn job, period.
okay.
You
Thank
know?
you.
Sorry.
All right. So here's the thing. What I can tell you, because I would have clients that would come to me. I even had somebody who was trying to be a nurse. They had went to nursing school. And they came to me after the fact and they say, hey, I have this theft case and they're not giving me my license because of this theft case. Can I get it expunged? Can I get it off? And I had to tell her, I'm sorry, you can't. You'll just have to get some people to write letters for you and maybe nursing will allow you to still have your license. So in the state of Texas and usually in other states as well, anything that requires a license, they run a background check on your criminal history. And if there is criminal history, I'm not saying it's impossible to get your license, but it's extremely difficult. I just went to felony drug court graduation. Someone has long history. They successfully graduated. And guess what? They are now a licensed attorney, but they had to have everything in order and make sure they were on a straight and narrow.
Correct.
So here's your choice. The 4 years, the probation, where the most you can get is 4 years, or either deferred adjudication. Which would you prefer?
I would pick probation, Your Honor.
Okay. All right. The court is going to find you guilty. The court will sentence you to 4 years in the prison, suspended and probated. What are you requesting?
4 years.
All right. Because of his history, I'm going to place him on for 5 years.
Okay.
All right. So 4 years in the prison, suspended and probated for 5 years. If he completes everything, I'll consider early termination.
Are you gonna be here in 2.5 years?
We shall see.
Good question, that is.
We shall see.
Yeah.
God willing, and the creek don't rise. So whether I'm here or not depends on things that are not in my control. All right. And your attorney knows what I mean.
Hey, question, 2 things. One is the ankle
Oh,
monitor.
excuse me, we're not done here.
Oh, yes, ma'am.
All right. See, that's why you should make sure you're clean and sober, okay?
Sorry. Yes, ma'am.
All right. So it's a $500 fine that will be probated. Proof of employment within 30 days.
Yes, I hear.
There's to be no employment as a home health care provider or with minors. Do you have any children?
No, ma'am, sure don't.
Okay. There's to be regular reporting by Zoom or in person. Regular UAs. If you could do a MIC evaluation. And I will tell you on the TAP evaluation, it doesn't mention what he's positive for today on there. So there probably needs to be an updated TAP for that, or either can I just order what I want to order? All right, so we're going to do intensive outpatient treatment with probation. And I'll do a referral to felony drug court. Felony drug court will be able to help him because they have a dual diagnosis program.
Good.
So they'll be able to help him with any trauma. The only thing There may be a waiting list because they haven't had their graduation yet. So if you want to talk to them and see, they may be able to accept him.
Okay.
But they'll only accept him one if he lives in Bear County. If he's not in Bear County, they won't accept him.
Are you in there?
Yes.
All right, so we'll do intensive outpatient treatment with probation, felony drug court. I'm gonna ask for 90 sober meetings in 90 days. They do have those online now, and they also have them throughout the city.
Nice.
And gonna do field visits one time per month until he is in treatment. Probation, is there anything else he needs? Community service hours? Yeah, 200 hours community service restitution. If you obtain a higher level education, because I see you have some college or some type of licensing, then the court will consider the community service hours satisfied.
Nice. Thank you.
Is there anything else? Probation?
Your Honor, did you want, you said regular UAs?
Yes, regular random UAs.
Nothing else.
All right, and with the UAs, if you wish to do it by a patch, you can do a patch. The patch, they put it on you, and that way you don't have to come down to probation for certain things, and then they will take it off.
Nice.
Everything is very nice with you today. All right, that's so 80s, but okay. Is there anything else that you need from the
That's
court?
why I think he needs a psychological evaluation.
Yeah, okay.
No, ma'am, but as I've said before, side note, I love how you're always kind of like me, like you're just happy, holly jolly.
Yes.
But yeah, that's all I want to say. Thank you.
Well, thank you. I appreciate that. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal.
Correct.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, did anybody want to address the GPS? He says he's on GPS.
Yes, he is, Judge, and he has inspections where?
All over the Bear County, Medina County, Wilson County, like all over. She allowed me.
He makes a very good living, Judge, but this,
Well, I tell you what, this is what I'll do. Since he makes a good living and it seems that he can afford the GPS, we will do GPS tracking only. And once the mental health issues are addressed, and once he's in the intensive outpatient treatment, once he's started that, then the court will consider removal.
And Judge, I don't know for certain, but he has several night mag pending cases that I don't know if that's associated with that GPS.
Okay, all right, so we'll keep the GPS.
your probation officer will put you in all
Okay.
these programs.
Okay, cool beans.
Yes, we're gonna keep the GPS.
Tracking only, Judge?
Yes, can we do tracking, or would you suggest not?
The GPS is through pretrial?
Oh, yes.
Ah,
And it was for this case, the 4200.
all right, well, he can afford
Correct.
he said he can afford GPS.
So what will happen is that monitor will be removed and then we'll have to get another monitor.
All right, so you're gonna be on GPS, but once you're in his mental health classes and once he's in intensive outpatient treatment, you can always come back. And if he's doing well on it, I would strongly consider removing it. All right. Is there anything else you need?
Thank you, Your Honor. No, ma'am.
All right, so in this court, communication is key if you want to be successful on probation.
Yes.
If there's an issue, talk to probation. If you feel they're not addressing it, you can come to court.
Okay.
All right.
Thank you, Your Honor.
All right, you're welcome. You're welcome. All right, so I'll put GPS tracking on there. And where is Mr. Cox?
Can I butt in and just?
Sure. All right, there you are. All righty. You're welcome.
Y'all are right down the hall from me.
Okay. All right, Mr. Barrera, we are waiting for that pretrial services officer to come in.
Okay.
And so Norma's gonna call her on the phone. If there's not gonna be any objections, we can just have her by phone instead of on Zoom.
Great.
Okay. And then Mr. Cox, you
No,
have,
no objection for the record.
okay, you have Mr. Harris. Are you all ready?
Yes, Sean, just have to get my, one witness, short witness, my investigator. She has a Zoom information, we can get her on.
Okay, yes.
I just got a phone number.
Okay,
I'm gonna call it from my cell phone and I'll just put her on speakerphone.
all right, thank you.
Even if you want the defendant back?
Yes.
Moses?
This is Mona. Where do you? It's okay, no, put it on speakerphone, okay? Give me 1 second. Valadez, can you hear me? Yeah.
All right, thank you, Ms. Valadez.
Sorry, Judge.
No problem. Are you able to hear? All right, we're gonna go back on the record in 2023 CR 3543, State of Texas versus Moses Ross. The court asked that the pretrial services officer zoom in. She's unable to zoom in. Is there any objection to her appearing by cell phone?
No objection from the state, Your Honor.
None from the defense.
All right, could you state your name for the record, please? All right, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. We are here on Moses Ross. Were you able to pull up his file? All right. There, he's saying that there's an issue with the GPS. Is there any type of issue?
Yeah, I know that most conditions are partial GPS with a no contact order. Let me double check if there's been any issues within, as well as including violations. There has been no violations. There has been an update letter that was submitted on October 11th of this year. No violations so far. I don't see anything in regards to issues with this defendant.
All right, so with regards to him, would you have an issue with him being on tracking?
No, Judge. I don't see a reason. He's been in compliance. I see no violations have been submitted. I don't see anything that's been entered in informing me that it would go against him being on tracking. No, Judge.
All right. Any other questions?
I do have questions. What are the exact rules for tracking and,
Tracking, you just don't have contact with the complainant
so there's
and
no,
they know where you are at all times.
yeah, so just keep it charged and go about my day, just
Yes.
don't go to her
Yes,
face.
I'm sorry, Judge. Can I say something?
yes.
So with tracking with pretrial, him being under our supervision, he doesn't have to go over a schedule with us. He doesn't need permission to go in and out of his house, but it is a 75-mile radius from Bear County restriction.
I can't leave anywhere.
75 miles.
I can't leave any issue.
Judge, if you would like to override that, if you would like for him to travel up throughout the state of Texas, that's not really a restriction. You can also order that as well. But within pretrial, it is so he can't go past the 7-mile radius without a full order.
All right, there's no reason for you to go beyond 75 miles.
No, ma'am. No, I'm not, no. I'm
No,
not
he'll
allowed to.
he'll be within the 75-mile radius.
Thank you, Judge. That's all that we have for tracking.
Is there anything else? Any other questions?
When does it come into effect? Because, I have,
It's in effect today.
thank you.
All right, is there anything else?
Nothing from the state, Your Honor.
All right, pretrial, is there anything else that you need from him?
No, Judge.
There's no curfew, nothing like that. Like, I don't want to get in trouble. I hate getting in trouble. I don't get in trouble.
There's an order to things. Any other questions from the pretrial service officer?
No.
No, Judge.
No, Your Honor.
All right, thank you so much for zooming in or trying to zoom in. And thank you so much for being by phone. No, I appreciate it. Thank you so much.
Thank you.
All right, you too. Bye-bye. All right, so this is what the court is gonna do. Court is gonna deny the motion, alter and amend conditions to include GPS tracking only. And when can he start the BIPP course? Do we know?
I have to do it. Right when I get out of here, I call them, I make an appointment with them. If they have any fallouts today, I could get it today, but usually they're about 4 days out. So it's not that far. So by next week, hopefully, I don't want to put it too close, but it's a holiday. Every time I've been calling lately, it's been about.
Okay, here's the thing, you're talking very fast. The court reporter, you're making her job more difficult than
sorry
it
about
needs
that.
to be.
Yeah.
All right, so probation, he needs to be enrolled.
Generally, Your Honor, he say within 10 days of whatever ruling of the court that the enrollment happens. So can we just give him the 10 days
Yes,
threshold? And I just want to confirm GPS alternate amending those conditions are bond conditions, not conditions of.
yes. All right, so you're to enroll in BIP no later than December 18th.
Yes, ma'am.
That's giving you more than 10 days.
Yes, ma'am.
Do you understand?
Yes, ma'am.
All right, if there's nothing else. All right. You're welcome.
Thank you, Your Honor.
Thank you. Have a good day.
Yes, sir.
Who's here on Ben Camarino?
That's me, Your Honor.
And if Mr. Cox, you can have your witness zoom in. Court is calling 2019 CR 9679W, State of Texas versus Ben Camarino. That party is announced for the record for the state.
Casey Garrett, Your Honor.
Defense,
Lorraine from?
are you Ben Camarino?
Yes, ma'am.
Going to show you what's entitled motion to enter adjudication of guilt and first amended motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Ben Camarino who was placed on deferred adjudication in 2019 CR 9679W for the offense of aggravated assault with a deadly weapon on September 23rd, 2019 for a period of 10 years? Is that you?
Yes, Your Honor.
State?
Yes, Your Honor, violated condition number 1 on or about the second day of November 2022 in Bexar County, Texas. That is defendant Ben Camarino committed the offense of possession with intent to deliver controlled substance in violation condition number 1.
How do you plead to that? True or not true?
True.
Your Honor, we'll waive the remaining violated conditions.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor, and that is to adjudicate guilt, revoke the individual office probation, sentence him to 7 years in Texas Department of Corrections. And the state will take in consideration cause number 2023 CR 6258, which he has pled true.
All right. Defense, is that the agreement?
Yes, Your Honor.
Mr. Camerino, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will follow your agreement, find you guilty. Sentence you to 7 years in the prison. Give you credit for any time served. There's an affirmative finding of a deadly weapon. Taking consideration 2023. CR 6258. There's an affirmative finding of family violence. There's to be no contact with Michelle, Michelle, Lubow, Lubow. And there's a $1,500 fine, time, and money to run concurrent.
And may I address the court on the
Yes.
back time, Judge?
Yes.
So he was a fugitive on this case since, let me make sure I've got this right. The warrant was issued on this MTR December 2nd, 2022. He was arrested and booked in Kerr County on December 21, 22. So we are asking that for the period of time he was in Kerr County and the warrant was outstanding here from December 21, 2022 through October 2nd, 2023, that he be given that time. He was, in other words, he was booked into Bear County, I think on October 3rd, 23. So he was in Kerr County from 12/21, 2022 through October 2nd, 2023.
I'll give him credit for any time that he was in custody in another county, as long as that credit is associated when this warrant was issued for a motion to revoke.
Okay.
So if the motion to revoke, and I believe what the court reporter has written, the motion to revoke was December 2nd, 2022, that's when it was issued. So if something happened before December 1st, he's not going to get credit for December 1st because no warrant was issued on this case. But from the time a warrant was issued on this case, if he was in custody in another county, then he will get credit for that.
Okay, so just for purposes of the judgment, do you want me to give something to the clerk?
Yes.
Okay, does the court want to make note of the Kerr County case numbers to run them concurrent? That might also.
Yes.
Okay, the Kerr County case numbers are B23.
Just 1 second.
Okay,
Yes, I'm ready.
B2383, B2384, and B2385.
And that's B as in boy?
Yes, Your Honor, as in Boyd. And I'll be here tomorrow. I'll bring something to the clerk.
All right, so this case is to run concurrent with Kerr County cases, cause numbers B2383, B2384, and B2385. Is there anything else with regards to sentencing?
No, Your Honor. Well, he also has time in safety. I guess I should mention that too.
Was it successfully completed? Probation, did he successfully complete safety?
Yes, Your Honor, twice.
Well, is it really a success if it's done twice?
You know, there was a lapse in time before he was sent back.
All right, I'll give you credit for time served in safety.
It's more than fair to say he has struggled.
All right, I'll give you credit for any inpatient treatment time. And if you would like, I can refer you to the therapeutic community. It will be up to them whether or not they accept you. Therapeutic community doesn't increase the time you're at the prison. Would you like that?
Yes.
All right. So I'll request therapeutic community, but you're going to have to ask for it as well. Okay. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement. Because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, and an affirmative finding of family violence. You're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak with an attorney. You understand?
Yes, Your Honor.
All right, we can go off the record. If you don't stop what you're doing, you're gonna find yourself living your life at the prison. If you don't want to be at the prison, if you don't want to become institutionalized, you're gonna have to make better choices. If you have a drug or alcohol problem, there are so many free places now for people to get help, but you gotta want it. And you gotta use the tools that are given to you once you're out of inpatient treatment. You understand?
Yes, Your Honor.
All right, good luck to you.
Thank you.
You're
Thank you,
welcome.
Judge.
You're welcome. All right, so, Mr. Cox.
Yes, ma'am.
Where's your witness?
She's on, I told her
No.
calling,
She's not,
she's not on the video, I mean, not on the Zoom. Oh,
she's not on the Zoom.
let me
So
call her.
anybody want to call her?
I'll call her again.
State, is there gonna be any objection to her just testifying from the Zoom? I mean, from the phone?
No.
Mr. Cox, they'll let her testify from the phone. If you'll put her on speakerphone.
Okay.
And then Norma, for the other people who are not here, we're gonna recall those cases for Monday. And if they don't show up on Monday, I don't wanna do it, but I may have to do a show cause.
Okay. Can they take them back or?
Let's have them here until we finish with this hearing. And once we're done with this hearing, then they can take them back.
Okay, yes, ma'am.
Could I see the remaining files, please?
She's online, I presume.
No, she's not in the waiting room.
They say,
She's not here.
they say you're not in the waiting room. They say, what's the trick that you all know?
It'll pop up on the.
Yeah,
They
it'll
said
show.
it'll pop up. One second, it says it should pop up.
Oh, thank you. You have a happy holiday too, and Merry Christmas,
So you
Happy New
should-
Year, Happy Kwanzaa, Happy Festivus.
They say you should
All
pop
right,
up on the
thank you.
screen if you're on. The judge should see you trying to get in.
Sure.
5 minute report, I've had chances to listen to you, and the patience in my pocket stays in my head a lot. I want you to know that.
Oh, I'm glad. Thank you. That's what my mom would always tell us. All right, have a good one. Okay, so this one, Norma, they have the judge's warrant on that one. So that just leaves Gonzalez, Perryman, and Padilla. And can I see the file on Harris? His client? It's Padilla's client.
Morning.
Hold on to it.
All right, thank you. So just put on speakerphone and we'll go.
We're gonna just put you on speakerphone, okay? We won't get a chance to see your face. One second. One second.
Do I sign into Google?
Did you have to do what to Google?
Yeah, where do I sign in?
No, you just can go to anywhere and it just, when you go to Zoom,
Go to Zoom.
and then you click on join. And then it's gonna ask you for a Zoom link number and you type in that Zoom link number and then you hit join again, and then you'll pop up.
We'll see a Zoom link.
Okay, there is no join on here.
No.
All right, we'll just do it by phone.
Zoom. I move YouTube to Zoom.
Okay, all right. All right.
All right, Deputy Laura,
I'm on Zoom.
you can go ahead and take Padilla back. Mr. Padilla, your attorney didn't show. So I'm writing in the docket sheet that your attorney did not show. And then Rudy Gonzalez. You're Rudy Gonzalez?
He's Mr. Padilla, and we have Tanya Ortega.
All right, I don't have the file for Tanya Ortega.
I'm looking for that file, Judge.
All right, and where's Marcelina Padilla? Is he still in the back somewhere?
Give me a second, Judge. I'm like, looking for you right now. Mr. Padilla's out here.
All right, Mr. Padilla. Yes, your attorney didn't show. We're gonna bring you back on Monday. And if your attorney doesn't show, we'll take care of that. Sure. All right, Norma. Dana, he's coming back on Monday. And then Perryman was a no-show. Where is Perryman?
They got this misjudged, so they filed a misdemeanor on it.
Okay, all right, thank you. Oh, and have I already filed the dismissal? Signed the dismissal?
I think so, because it says closed in the system.
Okay, all right, so that's done. And then Rudy Gonzalez.
Well, he's waiting for a psych eval. That's the one I told you over the lunch break, Judge.
All right, and what date do you want to put him on?
He said February 1st.
All right.
And then we take the forward. They're still here. There's someone. Okay. They're not gone yet. Whew.
So as soon as he comes back,
You see her now?
yes.
Okay.
Oh, she's entitled to me.
See, hang on.
Tanya Ortega.
All right.
2023.
All right, Ms. Kearns, if you can unmute and start your video. And we'll proceed on Mr. Harris.
If you want to, can we just,
Oh, if you all want to stand here, you can stand here or however you want to do it. All right, Carrie. if you can-
Unmute. Okay,
All right.
can you hear me?
We can hear you, but we don't see your video. We just see a nice lawn. No
Yeah.
music.
that's
Okay,
weird.
let me see here.
I recognize her voice, Joe, so.
It's okay if that's your screen, because everybody can recognize your voice and we know it's you.
Okay, yeah, sorry about that. You know I'm not techie, I have other talents.
No problem. All right, court is calling 2022 CR 3745, State of Texas versus Joseph Harris. Can I have parties announced for the record for the state,
Jason Garahan, Your Honor.
for the defense?
Cornelius Scott.
And are you Mr. Harris? All right, so my understanding is this defense is calling investigator Carrie Kearns as a witness. Is that correct?
That's correct.
All right, just so everyone knows, when I was in private practice, I would always use Ms. Kearns as the investigator for cases that I was involved with. Ms. Kearns, she and I have had lunch together. I do consider her a friend. I will tell both parties that I can be fair, and I will base my decision upon the facts that are presented to me and not my relationship with Ms. Kearns. So is there going to be any objection to me hearing this state?
No, Your Honor, she was the investigator during the trial and no objection from the state.
Defense? All right, so we're here on defendant's motion for a new trial. And defense, it is your motion.
Okay, thank you, Judge.
And Mr. Harris, if you'd like to step down, you're more than welcome to do so as well. And the court will note for the record that Mr. Harris is present.
Okay. All right, we would like to first call Ms. Kern.
All right, Ms. Kearns, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
My name is Carrie Kern, Kerri, Kern, Kern.
All right, defense.
All right. And Ms. Kern, you were sometime during the trial in this matter, you were appointed an investigator, correct? As
That
an
is correct.
Okay. And did you attempt to find a witness, in this case by the name of Ruben Vasquera?
Yes.
I think that's how you last name. So V as in Victor, AQUERA.
No, I thought it was Vaquera.
Oh, that's correct.
Yeah.
VAQURA, is that correct?
V as in Victor.
Vaquera. All right. And you made some attempts to try to locate that witness.
That is correct. I've spent a lot of time trying to locate him.
Okay. And were you successful in any of your attempts to locate this witness?
No, not to locate Ruben.
Okay. But you did you have a opportunity to review the statement that he gave the San Antonio Police Department with reference to this case?
Yes, I did.
Okay. Well, at this point, for the purpose of this hearing, we'd like to offer space. I'm sorry, defendant one. I've shown it to say they actually have a copy of it because they're the ones that gave it to me in discovery for the record, but I'm showing it to him again. Actually, I'm going to offer it in the evidence for the purposes of this hearing.
All right, any objection?
No, Your Honor, defense exhibit number one is the written statement made by Ruben Vaquera.
All right, and then the court then will allow the admission of defense exhibit number one, and the court will note that defense exhibit number one is included as an exhibit in the defendant's motion for a new trial.
Okay. Now, Ms. Ma'am, when you were seeking to locate this witness, you had an opportunity to review the statement, correct?
Correct.
Okay. And based on your experience of being an investigator, the importance of the purpose of this particular witness, were you able to determine in your experience any importance as to this particular case for this particular witness to testify if you could locate him?
By reading his statement, I can say for sure, definitely, we needed to interview him to get some clarity on a few things. And based on his statement, I think he needs to testify. Because he has a lot of knowledge.
Would you agree that he gives a vantage point, at least at the very even the beginning of the statements, of what the defendant in this case did or may have said and what was said to him initially during the confrontation?
So if I did watch the video too, and if I recall correctly, he stated he was sitting right behind Mr. Harris and he heard everything that the Hispanic young boy, that's how he refers to him, what he was saying.
Okay. What the lengths did you take to try to locate this witness?
So I immediately ran a comprehensive background check that gives me like everything, cars, last known address, his current address, his cell phone, this, that, and the other. And so I took from that and started contacting the cell phone numbers and and then the two addresses here in San Antonio I went to, but I didn't have any luck there. Then I believe it was maybe that Wednesday or so, I had finally gotten in touch with a family member, his grandfather. And his grandfather did explain to me that he had moved back to Austin, but the family had not heard from him in several months.
All right. Did you try to make contact or reach out to anyone or anybody or any sources in the Austin area?
No, we had gathered some different addresses from the Austin area and we just went to each one and either they didn't know him, never heard of him, or there was no answer.
Okay. I'll pass it.
All right.
Yeah, you're on.
Yes.
Good afternoon. Nice to
Hello.
see you. You stated that you watched the video, right?
Correct.
Of the shooting?
No, I watched it was a body worn camera of an officer standing next to him and he was talking with them.
Okay, so I guess my question was, did you actually watch the surveillance video from the Via bus?
The only time I saw that video was when we were in court.
Okay, and did you see Mr. Ruben Vaquera in that video?
I don't recall, I wouldn't have been able to make it out because the screen was too small and I wouldn't have been able to determine who was who.
Okay, but then you stated that Mr. Vaquera was sitting in back of the defendant, and tell me if I'm wrong, that's what I thought I heard you say. From that video, though, he was actually sitting in front of the defendant, Mr. Harris. Are you aware of that or not?
Okay, so I have not seen that body worn camera video in quite a while, but my recollection is that's what he had told the officers.
So if he would have told the officers that, he would have been wrong.
Well, I'm not necessarily thinking that he would be wrong as much as we just my recollection might be off. It's very possible that, you know, he was not sitting behind or in front. What did you say, front?
Yes, ma'am.
Yeah.
From the Via security video, Mr. Vaquera was actually sitting in front on the bench on the bus stop, and the defendant and Jason Lexion were sitting behind him.
Okay. Yeah, I have not seen the Via video.
Okay.
Yes, so I'll take your word for it.
Okay, well, and then moving on, I know that I saw you in court. You were an investigator for defense counsel or the defense case, but did you listen to other witnesses such as Michael McDowell? He was an eyewitness that was standing on the bridge when the shooting occurred.
In court or watch his video, watch the discovery?
Actually in court, ma'am.
I don't think I was there for McDowell's testimony.
Okay, and he was an eyewitness. And then what about William Fowler? He was another eyewitness that was in the white pickup truck. Were you here for his testimony?
I don't believe so, no.
And then also a Gonzalez Salinas and also a Humberto Colon.
I was not there for their testimony.
All right. And did you ever look up a work history or employment of Mr. Ruben Vaquera to track him down?
Yes, what I did was he has several social media accounts that state a different workplace, and most of them are hotels in San Antonio downtown area. And I have several sources that work downtown in hotels who know just about anybody and everybody. And the only place that recognized him was the Drury Inn.
And let me ask, when did you start looking for Mr. Ruben Vaquera? Was
The
it
week of the-
after? I'm sorry, go ahead.
No, go ahead.
I was just asking, was it at the time of trial or was that previous to trial?
Time of trial.
Okay, thank you. No further questions.
Thank you.
Just a couple. Did you, ma'am, did you issue any subpoenas to obtain any medical records of the deceased?
Yes, I did.
Do you recall where those subpoenas were issued to? Which agencies?
The state, San Antonio State Hospital is the one that I subpoenaed. Hold on, let me grab my witness list here. And university. I apologize, university.
Okay, were there any secondary subpoenas anywhere else? The state hospital? Did you do that also? If you remember?
We say that again, please.
You send out any additional subpoenas to the state hospital? If you remember.
No, I believe I only issued one.
Okay. Would that be in your notes anywhere? If you had sent some out that were sent to the district clerk instead of directly to me?
Yes, it would be in my file, but I only issued one subpoena for the state hospital.
Okay.
Just when did you issue that subpoena or try to present it? Well, let me ask you just a quick question.
Okay.
I don't need an exact time. Was it after the trial started?
That's correct.
Okay, no further questions.
Yes.
All right, any other questions?
Not from this witness.
All right, is this witness excused?
Not subject to recall front by the state. Yeah.
All right, thank you so much for zooming in. Have a
Thank
good
you.
rest of your day.
Thank
You
you.
too.
Bye-bye.
In addition, Judge, I'd like to offer exhibit number 3, number 2, that I presented to the state. And those are actually pictures of documents, not the documents themselves.
And Your Honor, no objection. I believe, Mr. Cox presented to me that these are the just pictures of the medical records that he obtained from, I believe, university that his investigator collected. So we don't have objections
All
for
right,
purpose of this.
state's
here.
exhibit number 2 and 3. I'm sorry, defense
Okay.
exhibits 2 and 3 is admitted without objection.
Right, in those is not, I actually have the records with, that's over 500 pages of records that were requested prior to trial, who wasn't actually gotten to me until the trial started.
All right, and these are records related to the complainant?
Yes, sir.
All right. All right, anything else from either side?
In terms of, no, Your Honor, in terms of evidence, that's it, and I'll just argue when it's at stake. I don't know if they're gonna continue.
We don't have anything to present, Your Honor, just argument.
All right, I'll hear brief argument.
Since,
Yeah, it's.
this is my motion, Judge, I'll waive opening and reserve everything for close.
All right.
That's fine.
State.
Judge, just since it's just fresh in your mind, the defense exhibit number 2 and 3, these records were obviously not requested by defense after the trial started by the investigator's own admission through testimony. But my understanding is he did receive, or rather the defense team did receive these records on at least by September 15th, which was on a Friday, before we broke for the weekend of Saturday and Sunday, and we restarted back up on Monday, September 18th. And so considering these records are, there are roughly 500 pages, but they're not thousands of pages. So it's something that could have been reviewed and subsequently was reviewed in the courtroom by many of us that were participating in this trial. So we don't feel that this is something that would hinder the defense's defense in this particular case. Addressing Mr. Ruben Becerra, I think the court is well aware eyewitness testimony is sometimes reliable, sometimes not. And in this particular case, the state brought forward no less than 4 witnesses that were eyewitnesses, well, at least 2 that were eyewitnesses to the actual shooting, one that was actually closer to the defendant and the deceased than Mr. Ruben Becerra, and actually had a better vantage point because he had no obstructions, because he was standing looking at each individual while the conversation, or rather argument, ensued there. And then we also have Mr. Fowler, that was an eyewitness that saw the defendant chasing down the complainant in this case and shooting him, and described that in very much detail as an eyewitness. We also had 2 different employees of buildings around that location that gave their rendition of what they saw immediately thereafter of the shooting and hearing the shooting. So in the case of Ruben Becerra, that he did give a statement that the state's position is somewhat inaccurate, because it doesn't follow the video, the via video that was entered into evidence. And if you read his actual statement and you compare it to that via video, it doesn't match up. And that's the case with Mr. Ruben Becerra. The state also looked for Ruben Becerra, was unable to find him or gain access to him. And I did mention that to Mr. Cox during the trial, that even before trial, I believe I mentioned that Ruben Becerra was not being able to be found by the state. And we did do our due diligence. We had looked for him for at least more than a month prior to trial, and through different sources that we looked through, including worksite sources and other sources. And that the state's position is that this motion for new trial should not be granted.
All right, Vince.
Judge, my position is that when you, in terms of a defendant charged with a crime, there was some evidence that the complaining witness mannerisms and some things he was seeing was nonsensical. It was something that really didn't make a lot of sense. We tried to get to the issue of whether or not there was some mental health issues that he had. It's fair to see that from the discovery in this situation, the state, they never delved into it or attempted to look into it, because if they had, they would have had to give that information to us. I can see that it appeared that they may have known there was a possibility of it, but they didn't delve into it. The problem you have is that you have, why Mr. Becerra, Becerra, guess how you pronounce it, that's probably wrong, but his statement at trial, if he was locatable with. He was the one that was saying that this person was saying nonsensical things like, get off my block. I'm trying to why you're texting me. That didn't make a whole lot, didn't make a whole lot of sense. But as far as the defense, it would have showed something that there may have been a mental health issue with the complaining witness. Now, what happens is that we by not getting anything directly from the prosecution, we were just trying to locate anything from any other source that may suggest that there was an issue. We find it, but it's after the trial has started that the records actually came in. I requested a continuance on it. More than 500 pages, 500 pages that will show that not only did the complainant have mental health issues, that he had been hospitalized. There was an issue in this trial about a weapon, that the complainant actually bought a weapon. Now, what we learned later was that because if he voluntarily went to a mental health hospital, no matter what the diagnosis, he don't get the red flag. So you can go into a mental hospital for weeks or months, have bipolar, hallucination, anything. And if you go in there voluntarily, it seems like nobody flags him. So you can go out, you can leave the mental health hospital, go across the street, and buy any type of weapon that you want. In this case, the state indicated that during the trial, that both parties were lawfully carrying. Which was not the truth, because for the complaining witness, they lawfully carried them.
I just object to that portion, Your Honor.
Someone have to be in a holster. Okay, so my position, Judge, is that by the 500 mental health pages of mental health records that we have that will show hospitalization, the defense was at a disadvantage in terms of preparing a defense that would bring more to light the mental health aspect of it, because with not having the witness Ruben Bacara, not having him, when he would be, based on his test, based on his statement to police, that would show these type of erratic statements from somebody that we later found out had been hospitalized, severe mental health issues, more than one occasion. We feel that the combination of those things, SAFE didn't offer us anything, didn't delve into it, prevented our client from having a fair trial. And we feel that based on that, he should be entitled to a new trial.
All right. Thank you so much. All right, the court has heard arguments from both sides. Court listened to all the evidence, internalized it. The court is going to deny the motion for a new trial. All right, and Mr. Cox, are you going to withdraw and someone else is going to do the appeal?
Yes, I'm going to file the paperwork hopefully by either tomorrow or Monday for the appeal, and to withdraw and have the court appoint someone, because my client is obviously not able to afford an appeal because he's incarcerated.
All right, so we will make sure that you have an attorney appointed. I don't necessarily appoint the attorney. It's just so you know, it's on a rotation. So whoever is next up on the list who does appeals, that will be the person that will handle your appeal. So people have to actually sign up for the appellate will, and there are a host of conditions and classifications for people who do appeals. So you'll get someone who actually does appeals to represent you.
Do I need to sign up my anything?
No, you don't need to sign anything. What will end up happening is an appellate attorney will be appointed to represent you, and that attorney, if need, will get in contact with you. All right.
All right, thank you very
All
much.
right, you're welcome. Thank you. Could you hand that to Diana? All right, Tanya Ortega. In state, I don't believe you all had a chance to review anything on this.
No, Your Honor, it's not.
All right, so we're gonna recall this case. Ms. Ferguson, can you recall this for? Let me see. In December, can you call it the week of December 11th?
I can do the 11th.
All right, we're gonna come back on December 11th, and Norma, give everybody the reset form, and please put 9 a.m. on that. So we're gonna come back on December 11th. And that's gonna be at 9 a.m. All right, thank you. And they'll give you a reset form. All right, and I believe that